Imagine you are staring down a massive, just totally intimidating legal contract.
Yo, yeah, we've all been there.
Right. It could be, a new employment agreement or
Yeah.
like those sprawling terms of service for that app you just downloaded.
The ones nobody actually reads.
Exactly. The ones nobody reads. Or maybe you are just trying to make sense of a news headline about like a really dense Supreme Court ruling. It feels so overwhelming.
Because it feels like it is written in a completely different language, honestly.
It really does. Usually when you approach these documents, you assume you just need to read the words on the page. But there is actually this hidden set of rules governing exactly how those words are supposed to be read.
Right, how they are defined and, what happens when they inevitably contradict each other.
Yeah, and it is remarkably similar to trying to play a complex board game without knowing that half of the foundational rules aren't actually in the box.
Oh, that's a great way to put it. They are printed in a completely different manual.
Right. You might be able to move your pieces around the board based on what you see, but you are not really understanding the mechanics of the game you are playing.
And uncovering that hidden manual is basically our mission for today's deep dive.
Yes, it is. We are looking at the mechanics of the General Clauses Act of 1897. Now, I know, at first glance, an 1897 law sounds like we are dusting off an ancient, irrelevant textbook.
Like something that belongs in a museum.
Right, exactly. But stick with us here. This specific act is actually the hidden master key. It is the underlying operating system for the entire Indian legal framework.
It really is. This is about equipping you to read laws and contracts like a true legal insider.
Which is such a superpower.
Oh, absolutely. Once you understand the mechanics of this 1897 Act, you can completely bypass the overwhelm of all that dense legal jargon. You start seeing the architecture behind the text rather than just, getting lost in the words themselves.
Okay, let's unpack the history here before we get into the modern stuff. Take us back to the late 19th century. Why did lawmakers suddenly feel the need to create a law of laws to govern all the other ones?
Well, it came down to a massive, just paralyzing efficiency problem. The General Clauses Act was enacted on March 11th, 1897.
Okay.
And the goal was to consolidate and extend some earlier, more fragmented acts from 1868 and 1887. You have to imagine a legal system where drafters are creating hundreds of complex laws by hand or like early typewriter.
Oh, wow. Yeah, no copy and paste back then.
Exactly. So if in every single law they write, they have to explicitly define what a document is or what a person legally means, the law books are going to become endlessly repetitive.
Just mountains of redundant paperwork where, 90% of the document is just throat clearing before you even get to the actual law.
Right. So the overarching goal was to shorten the language of central acts and to ensure absolute uniformity of expression across different pieces of legislation.
And I guess to guard against oversights, right?
Precisely. To guard against oversights or slips by the legislature. The Supreme Court actually articulated this beautifully in a well-known case, the Chief Inspector of Mines v. Karamchand Thapar.
Oh, I've heard of that one. What did they say?
The court explicitly stated that the purpose of this act is to place interpretation rules and standard legal principles into one single statute to avoid what they called superfluity of language.
Superfluity of language.
Yeah.
That is a wonderfully polite, lawyerly way of saying, please stop repeating yourself so much.
It really is, because if they didn't have this overarching act, these interpretation rules would have to be specified separately in hundreds of different acts.
Which would inevitably lead to contradictions, right?
Exactly. There is a very practical example of this regarding the legal power to appoint someone to a position.
Okay, lay it on me.
In legal proceedings, a court might be given the power by a specific law to appoint your receiver, which is essentially a neutral third party assigned to manage property or assets that are currently the subject of a biddle dispute.
Right, so a specific law gets drafted, and it simply says the court may appoint a receiver. That seems straightforward enough.
It does, but consider what happens when that receiver does a terrible job or acts corruptly. Does the court have the power to fire them?
Oh, I see where this is going.
Right, because if you look only at the text of that specific law, it might only grant the power to appoint. It says literally nothing about firing.
So they're stuck with a corrupt receiver.
Well, this exact scenario played out in a case called Rayarapan v. Madhavi Amma. The court had to step back and look at the General Clauses Act.
The master key to the rescue.
Exactly. It ruled that because of this 1897 act, whenever a modern law provides that an authority has the power to appoint a receiver, it is automatically implied within that language that the authority also has the power to suspend or remove them.
Okay, let's unpack this. This act is functioning like a universal coding library for software developers.
That's a great analogy.
Yeah, like instead of a programmer having to write the underlying granular code for a basic copy and paste function into every single new app they build, they just write that code once into the operating system itself.
Exactly.
And then every new app just references the OS. The legislature wrote the suspend and remove code once in 1897, and now every single modern law just silently runs it in the background.
That is perfectly said. It provides uniformity as far as possible, importing common form clauses into every single act so the drafters don't have to constantly remember to insert them. It's a permanent safety net.
Okay, so if this operating system is handling the mundane background code like appointing and suspending, what happens when the actual law drops the ball on a critical, highly contested definition?
You mean like a massive oversight?
Yeah, I'm talking about massive oversight that threatens to derail a major dispute.
Well, that is where the General Clauses Act really flexes its muscles. It steps in when there is an absolute absence of a clear definition in specific enactments.
Which brings us to the fish.
Yes, the most fascinating illustration of this is the case of Ananda Behera v. State of Orissa.
The fishy riddle. This is honestly one of the strangest legal debates I've ever heard.
It's wild. The court was faced with a seemingly absurd but financially significant question. Is the right to catch a fish considered movable property, or is it immovable property?
I have to stop you right there. Wait, a fish literally swims.
I know.
It propels itself through water. It is the very definition of movable. How can anyone look at a swimming fish in a lake and even attempt to argue that it is immovable?
It sounds completely counterintuitive from a biological standpoint, obviously, but we have to look at the legal mechanics of the dispute.
Okay, lay out the mechanics for us.
The specific law at play in this case was the Transfer of Property Act. The problem was that Section 3 of that act does not actually define the term immovable property in a positive way.
What do you mean by a positive way?
It only gives a negative definition. It simply says immovable property does not include standing timber, growing crops, or grass.
Which is uniquely unhelpful when two parties are sitting in a courtroom arguing over the rights to catch fish in a lake.
Uniquely unhelpful is right. Since the Transfer of Property Act failed to provide a positive definition of what immovable property actually is, and while fish clearly aren't timber, crops, or grass, the court was stuck.
So they hit a dead end.
They did until they looked to the safety net. The General Clauses Act swoops in. Section 3, subsection 26 of the Act defines immovable property to include land, things attached to the earth, or, and this is the crucial phrase, benefits to arise out of land.
Wait, benefits to arise out of land? So the argument wasn't about the biological fish itself swimming around in the water.
Exactly. The court utilized a legal concept known as profit à prendre, which is a French term translating roughly to a right of taking.
Okay, a right of taking.
It is a concept that enables a person to share in the land owned by someone else. So to take a part of the soil, the minerals, or the natural produce of that land.
Oh, I see.
So the legal right to enter a property, catch fish, and carry them away is considered a profit à prendre. Because it is a financial benefit arising out of the land, specifically the pond or the lake bed that holds the water, it falls perfectly under the General Clauses Act's definition.
Wow.
Therefore, the right to catch fish was legally construed as immovable property.
That completely flips the perspective. The law isn't regulating the animal, it's regulating the spatial right to access the environment the animal occupies.
Precisely.
It makes you realize how a 19th century safety net is forced to catch these incredibly nuanced disputes. If they didn't have that benefits to arise out of land clause from 1897, the entire legal process would have just ground to a halt over a swimming fish.
It provides a definitive, unarguable anchor when a specific statute is totally silent. It basically forces the system to keep moving.
Okay, so the Act fills in blank definitions to save us from legal gridlock. But how does it help us read the actual structure of a law when we finally sit down with a document in front of us? Like, how do we decode the anatomy of legislation?
Well, to understand the anatomy, you first need to understand the journey of the text itself. Like, how does a document even earn the title of a law?
Right. It doesn't just magically appear.
Exactly. It begins its life as a bill, which is merely a drafted legislative proposal put into a proper structured form. It only transforms into an active act after it survives a very specific, rigorous gauntlet.
A gauntlet. I like that. What are the steps?
It must be passed by both houses of parliament, it must receive the formal assent of the president, and finally, it must be officially notified in the Official Gazette of India.
So it isn't a law just because a politician wrote it down on a napkin. It has to survive the gauntlet.
Yeah.
And once it does, what is the first structural element you encounter when you open it up?
Almost universally, you will first see the preamble.
Ah, the preamble.
Yes, the preamble is a formal part of the enactment itself, and its designated job is to express the scope, the object, and the ultimate purpose of the act. It is essentially the primary source for understanding the grand intention of the lawmaker behind all that dense legal text that follows.
You know, I was trying to visualize this earlier, and the preamble feels a lot like a movie trailer, or maybe like the mission statement on a corporate website.
That's actually a great comparison.
It tells you the general vibe. It tells you what the overarching goal of the project is. But if the actual movie script contradicts the trailer, the script is what actually happens on screen. The trailer doesn't change the movie.
That is an incredibly accurate way to view it. The preamble is a vital aid to construction whenever there is ambiguity in the text.
So you use it to break a tie, basically.
Exactly. If a specific word or phrase later in the statute has more than one possible meaning, and a doubt arises as to which meaning the drafters intended, the court is obligated to refer back to the preamble to figure out the proper context.
Okay, but what if the text is super clear, but it just doesn't match the preamble?
Then the legal rule here is absolute. The preamble cannot override the plain, explicit provisions of the Act itself. If the language of the specific statute is crystal clear, the text of the statute wins every single time, regardless of what the preamble claimed the goal was.
Got it. So what does a real preamble actually sound like? Are they these long, philosophical declarations?
Surprisingly, no. They are usually very brief and functional.
Really?
Yeah. For instance, the preamble of the Negotiable Instruments Act of 1881 states it is simply an act to define and amend the law relating to promissory notes, bills of exchange, and check.
Very utilitarian.
Hurry! Or look at the Massive Companies Act of 2013. Its preamble just states it is an act to consolidate and amend the law relating to companies.
Short and to the point. Setting the stage. Now, moving past the preamble, you usually hit the definition section. But what's fascinating is that these laws don't always define their own terms, do they?
No, they don't. Usually an act contains its own dedicated definition part, typically located in Section 2 or sometimes Section 3. But sometimes words borrow their definitions from completely different laws.
Like a legal crossover episode.
Exactly like a crossover episode. There's a really good example of this in the Companies Act. The word security is used heavily throughout the text, but the Companies Act doesn't actually define it.
So where do they get it?
Instead, Section 2, subsection 95, specifically states that words not defined within it, but defined in other specific acts, will carry those external meanings. So the concept of a security borrows its entire legal weight from Section 2 of the Securities Contracts Regulation Act of 1956.
And I imagine this happens with newer concepts, too. Like, if an old law talks about digital signatures, it has to pull that from a modern tech law.
Exactly. The term digital signature used in the Companies Act gets its precise meaning construed from Section 2 of the Information Technology Act of 2000.
That makes a lot of sense.
And tying this entire concept back to our main topic, if a common legal word like affidavit is used in the Companies Act, and it isn't defined there, or in the IT Act or in the Securities Act, it defaults back to the ultimate dictionary of last resort.
The General Clauses Act of 1897.
You got it. It derives its meaning straight from there.
Finding out where the definition comes from is one thing, but here's where it gets really interesting. The specific verbs used to introduce that definition completely change how you were supposed to apply it in the real world.
Yes, this is where we get into the secret linguistic codes of the legal system.
We are talking about the profound difference between the words means, includes, and the difference between shall and may. These aren't just stylistic choices by a writer, are they?
Not at all. They are highly engineered legal tools.
Okay, let's start with means versus includes. How do those two words alter a sentence?
Well, when a legal definition uses the word means, it is an exhaustive definition. It gives you the exact, restricted, unchangeable meaning of the term, and absolutely nothing else can be added to it by a judge or a lawyer.
Okay, give us an example.
For example, Section 2, subsection 34 of the Companies Act states, director means a director appointed to the board of a company. That is a closed loop. If you aren't formally appointed to the board, you aren't a director under this definition, no matter what your business card says.
Okay, so I picture the word means as a closed VIP room at an exclusive club. If your name isn't explicitly on the list at the door, you do not get in. There is no negotiating.
I love that analogy. On the other hand, when a definition uses the word includes, it is extensive and open-ended. It does not strictly define the parameters of the word. Rather, it expands its natural meaning to ensure certain edge cases are covered.
Ah.
For example, Section 2 of the Companies Act says debenture includes debenture stock, bonds, or any other instrument of a company evidencing a debt. It dictates that a debenture is all the things we normally understand it to be in finance, plus these specific items listed just to be safe.
So a quick includes is like an open house party. The list on the flyer is just a suggestion of who might be there, but anyone related to the general vibe can walk through the door.
Spot on. And there are also a few hybrid variations.
Oh boy.
If a definition says means and includes, for instance, how a share means a share in the share capital and includes stock, the courts consider that exhaustive. The VIP room is closed.
Okay, what about the open house?
If the text says apply to and include, the definition is understood as extensive. The open house remains open. You also have terms like body corporate, which the law says includes a company incorporated outside India. It doesn't attempt to define body corporate entirely. It just ensures foreign companies are explicitly invited to the party.
That logic tracks perfectly. But now we have to tackle shall and may. In everyday English, these are very distinct concepts. If I say I may go to the store, it's a possibility. I haven't decided. But if I say I shall go to the store, I am making a firm commitment.
The legal application starts from a similar premise, but introduces a massive and often really frustrating twist.
Why am I not surprised?
Generally speaking, the word shall is used by drafters to raise a presumption that a provision is mandatory or imperative. You must do it or you are breaking the law. The word may is used to connote something that is not mandatory. It is directory or enabling. You are granted permission to do it, but you hold no obligation.
Okay, that seems simple enough. Where is the twist?
The twist comes down to interpreting legislative intent. Sometimes the words may and shall can be interpreted interchangeably, depending on what the lawmakers were actually trying to achieve.
Wait, interchangeably.
Yes. Section 3 of the Companies Act states that a company may be formed for any lawful purpose.
May be formed. So forming a company is optional.
Forming a company is an optional endeavor, yes, but legally, the usage of the word may in this specific context actually operates as a mandatory shall.
What? How does that work?
If you choose to exercise the option to form a company, it makes it absolutely mandatory for you to comply with the rules of Section 3. You cannot form a company without complying with it. The permissive may transforms into a strict, unyielding requirement based on the context of the action.
Wait, I have to push back on this.
Right.
If man essentially means shall, the English language loses its meaning. Why even have distinct words? Why don't legislators just write exactly what they mean?
It is a completely fair frustration.
It feels like they're deliberately writing in a code that forces everyone to hire a lawyer and go to court just to figure out what a basic verb means.
It's one that law students and judges wrestle with constantly, trust me. But the reason lawmakers don't just use rigid language is that laws are written to cover a vast, unpredictable array of future circumstances.
So they need wiggle room.
Exactly. Drafters use the word may to grant a broad power or a privilege to a citizen or a government body. But the underlying context dictates that if the specific conditions for that privilege are met, exercising it must be done in a mandatory, highly regulated way to prevent chaos.
Okay, I guess that makes sense.
The General Clauses Act helps courts navigate these semantic nuances by providing a standardized historical backdrop, but ultimately it requires careful interpretation of the specific statute's broader goal.
It requires a decoder ring, basically. And that brings us to a massive realization about the reach of this blueprint. So what does this all mean? If this 1897 code is doing all this heavy lifting, overriding English grammar, defining fish as real estate, bridging the gaps between modern tech laws and corporate laws, where does its jurisdiction actually stop?
Its reach is remarkably vast, partly because of what it doesn't say.
What do you mean?
One of the most interesting details is that the General Clauses Act does not contain a specific territorial extent clause.
Meaning it doesn't say this law only applies in these 3 specific states.
Right. Its application is tied directly to the legislation it is interpreting, rather than a spot on a map. It is primarily applied to all central legislation and all the rules and regulations made under those central acts.
So it just follows the laws wherever they go.
In a sense, it acts as a phantom limb to every central act. If a central act is formally extended to a new territory, the General Clauses Act automatically tags along with it to apply its foundational rules of construction.
It's the ultimate +1. Wherever the Central Act goes, the General Clauses Act gets through the door.
And it covers an astonishing timeline. It applies to modern acts of the Indian Parliament, of course, but also applies to acts of the Dominion Legislature, those laws passed during the turbulent transition period between August 15th, 1947 and January 26, 1950.
Wow, okay.
It even applies to acts passed before the commencement of the Constitution by the British Governor-General and Council.
So it bridges the gap from colonial rule through the chaos of independence right into the modern republic.
But the absolute peak of its jurisdictional power is found in Article 367 of the Constitution of India.
Oh, wow. The Constitution itself.
Yes. This article explicitly authorizes the use of the General Clauses Act to interpret the text of the Constitution itself. The article dictates that unless the context otherwise requires, this 1897 Act shall apply for the interpretation of the Constitution in the exact same way it applies for the interpretation of a standard act of the legislature.
I want you to really think about the chronological whiplash of what that means. We are talking about a law drafted in the 19th century.
Yep.
An era before cars were mass-produced, before commercial airplanes, before the internet or digital signatures. And that exact same colonial-era document is literally authorized to interpret the modern constitution of the world's largest democracy today. That is absolutely mind-blowing.
It truly is a testament to the durability of well-constructed legal principles. Because of its effectiveness, the General Clauses Act also serves as a necessary blueprint for state General Clauses Acts.
So the states copy it too.
State legislatures purposefully conform their localized acts to this 1897 master model. If they didn't, you would have completely divergent, chaotic rules of construction across different regions.
Oh, nightmare.
Oh, absolutely. Also, as a quick definitional note to show its encompassing, unifying nature, the Act clarifies that the term government legally includes both the central government and the state government.
It just covers all the bases. It is the invisible glue holding a massive, constantly evolving system together.
Invisible glue is an incredibly apt description. While other legal systems around the world might call similar legislation an interpretation act, the title General Clauses Act is entirely appropriate here because these specific clauses are the common baseline for every central act in the country.
As we wrap up this deep dive, I want to bring it back to you, listening to this. Why should you care about the mechanics of an 1897 law? Because whether you are signing a new employment contract, clicking agree on a seemingly standard terms of service agreement, or just trying to understand the nuances of a massive Supreme Court ruling in the news, knowing these hidden rules gives you a distinct edge.
Exactly. When you understand the weight of a preamble or the hidden traps lurking in the words includes versus means.
Or the reality that a simple may might actually be a mandatory command in disguise.
Right. You stop being a passive reader. You become a critical, empowered consumer of information. You actually understand the rules of the game.
You are no longer just looking at the surface of the document. You are reading the matrix underneath it. But before we sign off, there's a final thought I want to leave you to mull over, building on the sheer durability of everything we've discussed today.
Yeah, think about this. If this 1897 Act acts as the ultimate dictionary and safety net for the entire legal system, anchoring physical, spatial concepts like things attached to the earth to resolve disputes about fish and lakes,
Right.
how is this Victorian-era master key going to hold up in the near future? When lawmakers start drafting central acts to regulate virtual real estate in the metaverse or property rights for asteroid mining in outer space, will the 1897 definition stretch far enough into the digital and celestial realm?
That's a wild thought.
Or will we finally hit the breaking point where a new General Clauses Act is required for the modern age?
Now, that is a question worth thinking about the next time you find yourself staring down the fine print. Thank you for joining us on this deep dive, and we will catch you next time.